screen?
No. No,
And
we can't.
You can't.
Nope. This is Greg Murphy. I cannot see it.
No, it's we've got a indicating that you're not transmitting. It looks like a camera with a bar. So don't know.
Hey, Greg.
Hello.
Sorry, that's my bird.
Wow.
Oh, there we go. Hey, there's Dr. Henderson.
There we are. Very good.
Perfect.
I forgot to press the last button that says actually to share it. So I appreciate your patience with me on that. Golly, all right. I thought I had it. And yes, so the technical report, as you potentially observed, is fairly long and rather technical about and its description of the study. And so what I would like to do with this deck, assuming that everyone has some familiarity with that report, and because you have all lived this project from the beginning, assuming, I can reasonably assume that you are familiar with the different building blocks that we used to bring the study to its final state. So I'll move along fairly expeditiously, but if you have a question about anything, don't hesitate to let me know, and we'll do our best to give a good response for that.
I saw Greg raising his hand. Correct, Greg? Do you have any
Thank you,
questions?
Ron. Can you all hear me, or can you?
Yes.
All right. I received this a draft report and the technical report Friday evening. That's Good Friday evening after working hours. And I just offer the comment that I have not had adequate opportunity, in my view, to study the report. So while I have some familiarity based on the process generally and reading through it as much as I could get through over the weekend, I just note that this has not been, in my view, adequate time to review all the material.
Okay.
Certainly understand. So the purpose for conducting the study was to identify the, to build a structure for linking the content of the California bar exam to the practice of law in the state. And practice analysis as a methodology is useful for that purpose because it gives a data-based documentable linkage. And it's the most commonly applied validation strategy for licensure tests. There are other validation strategies depending for other types of tests, but content validity is the name of the game when it comes to credentialing exams. And practice analysis is the widely required methodology for doing that. And so the last sentence that's showing on the screen now, validation through systematic practice analysis helps to document that the competence to be inferred when candidates have passed a professional licensure examination bears a strong linkage to practice. And that is the key validation point that has to be addressed when an organization hopes to be able to defend the content framework for its test. And so the practice analysis report lays out in some detail how this group appointed a practice analysis panel. And we worked with that group for 3 days in March of 2019. And they detailed an outline that is in the appendix of the report, and also is the description of practice and the knowledge and skills that attorneys need to possess in order to carry out their responsibilities in a proficient way. And it's organized around areas of responsibility with each of those, there are 4 of those, and each has a set of competencies. And altogether, there are 13 competencies spread over the areas of responsibility. And then each of the competencies has a set of task statements that are more finite in their scope and that detail the actual work that a competency implies. Alongside that framework, there is a framework of legal topics with subtopics. And the group developed 19 legal topics as subject areas in law. And then each of those has some number, normally a small number, of subtopics that give a little detail about what that legal topic is. And then for each of those, the group listed a set of sources that would be considered definitive for the subtopic. And so I indicated regarding the 4 areas of responsibilities and the 13 competencies that the 13 competencies were spread over the 4 areas of responsibility, and they're listed here. These are statements that we have worked with the working group for quite some time, so I'm sure that you are familiar with these. We collected data on these through the survey, along with, and there were 2 survey projects that we employed. The rating scales in the surveys are on the next several pages. But the point of the survey of, yes? The point of the survey was to collect data from attorneys practicing broadly across California, to collect data that would indicate the degree to which the competency, the area of responsibility, and the task, also the legal topics and subtopics, pertain to practice. And so we used several scales to accomplish that. We wanted to know how frequently the area of the attorney worked in the area of responsibility. And so for the traditional survey, we used a rating scale for that. We also wanted to know that if the attorney believed that failure to perform the area of work proficiently might result in harmful consequences to clients and other members of the public. There also was a 3rd scale. We didn't use it for the areas of responsibilities or competencies, but for tasks, we asked at what point in the attorney's career he or she was first expected to perform the task. The 19 legal topics also used rating scales. We wanted to know the frequency and criticality of those. And then for subtopics, for frequency and criticality for legal topics and subtopics. When the participant in the traditional survey was given the list of the 19 legal topics, we asked that he or she indicate those that were pertinent to their practice. And based on what they selected, the survey branched and collected the additional data on frequency and criticality. So the scales, frequency, asked in the traditional survey how frequently the work activity was performed by the individual or that the legal topic was applied. Criticality is for the degree of harm. I'm sorry, did somebody need to ask a question? Okay, so then criticality was the degree to which harm might result if the attorney is not proficient in the area of responsibility, the competency, the task, the knowledge areas, legal topics. And so there was that scale that was used for both the traditional and the ESM surveys. I should say that in the ESM survey, the notion of frequency was addressed not with a rating scale, but by the number of people who indicated that the task that they were performing at the time they received a ping was to be classified in the competency. So it was based on the actual work that they reported that they were doing at the time. In the traditional survey, we did ask for the performance expectation for tasks, and this information is useful in validating that attorneys need to be proficient early in their practice, or if proficiency can be developed somewhat later. So for the ESM survey, in addition to frequency and criticality, the depth of knowledge was a scale that was used for the legal topics. And so the way that that survey worked, they identified what tasks they were performing, and they rated its criticality. And then they were asked what area of knowledge they were drawing on in order to perform that, and what depth of knowledge that particular task required in that topic area. And so they used this scale that has some linkage to a very widely used taxonomy for the cognitive domain. And so with the survey design, as the surveys were designed and ready to implement, we took the 190,000 attorneys who are licensed to practice in the state, and divided it into 3 groups of 63,330 each. 1/3 for the traditional survey, 1 group for the ESM survey, and then the 3rd group for the National Conference of Bar Examiners survey, which ran at just about the same time that ours did. That's by coincidence, but it was a pretty happy circumstance. So 63,330 is the starting point for the sampling plan. People were randomly assigned into those groups. And then the level of participation that we received was really quite good for the traditional survey. We had some data from not quite 24% of that very large sample. However, the survey was long and fairly complicated, and we lost people as they made their way through. But 8.3% of the sample submitted a complete response for the traditional survey. And so that compares favorably to the 7% rate of participation in other state bar surveys over the past several years. So we were pretty pleased about that. For the ESM survey, more than 10,000 attorneys agreed to participate. So that is about 16%. And then 118,000, 117,000 pings were sent out over the next several weeks, and we collected not quite 74,000 responses. So given the 10,000 who, given the number of pings sent out, the level of participation was really quite strong. And so because of the need to focus on entry to practice, where the information that's provided on the table here shows that we had a healthy percentage of the participants who were in the first 3 years of their practice for both the traditional survey and the ESM method. One of the really important things to look at when you're doing a survey and you're going to make data-based decisions on it is how reliable the data are. We were very pleased with the reliability statistics. These coefficients range from 0 to 1, and generally the closer to 1, the better. For the 4 areas of responsibility in the traditional survey, we had statistics that were quite high, 0.93 to 0.98, and very high also for the ESM survey at 0.87 and 0.88. Legal topics in the traditional survey, 0.79 to 0.94, and very high in the ESM survey. Normally, reliability statistics that meet a threshold of 0.7 are considered acceptable for most purposes. And so we feel like we've exceeded that handsomely through both of the surveys. And so, this is a mountain of data. We wanted to cut it down, especially for this conversation, to the most meaningful elements. And so for the areas of responsibility, you can see that given the scale for the criticality, that we have a fairly strong set of means here, which does suggest that individuals who are not proficient in the performance of work in these areas would bring about substantial harm. And we had similar findings for the ESM method, and then for the frequency, the second table here, it's clear from the traditional survey where we used a rating scale that attorneys work in these areas quite frequently. And then the ESM survey was a direct assignment from the task that they said they were performing at the time that they received the ping, as it was classified in the 4 areas. And so it's clear from both sets of data that factual and legal analysis is performed most frequently under both survey methods. next aspect of the data that we collected that I wanted to share with you regards the competencies. And so we have ESM frequency data, the experience sampling method survey data provided in the first two columns, and traditional survey in the third and fourth columns. An interesting problem that we face when we are trying to make sense of data from two different data collection strategies is how we can combine them in a way that makes them comparable. And so what we did to do that was to compute really z-scores for the data in both survey methods. So this results in a standardized distribution, and for both survey methods with a mean of 10 and a standard deviation of 5. And so since the information that's in the second column and the fourth column are both on the same scale, it's comparable information. And so what we've done is to use that scaled statistic for frequency for the ESM and the scaled statistic for traditional criticality based on the decision of the working group several meetings ago to compute a composite, which is the simple average of the information in column 2 and column 4. And then I ranked them here in this table from the highest to the lowest. And so the 13 competencies are all shown here. And you can see that we have drafting and writing at the tip top, and then some areas at the bottom that might be less important to the practice and to the assessment of practice listed at the bottom of this table. For the legal topics, we did the same thing. The ESM frequency is the number of instances in which the legal topic was cited as important basis for performing the task that was identified at the time of the ping. And then the traditional survey criticality scale is the other tool that we are using to compute the composites. The ESM frequency traditional ratings were both standardized using the same strategy as for the competencies. And then the composite in the rightmost column in the table is the average, and the 19 legal topics are ranked from the highest value or valence to practice to the lowest in this table. And so the last slide that I wanted to share with you is based on the decisions that the working group made in its meetings last fall. And we really spent a lot of time here thinking through what the construct for the bar exam might be, and the the assessment that would have the most valence for the California bar exam. And so using the data from the survey, along with a lot of conversation and some amount of judgment on the part of members of the working group. The listing of competencies and legal topics that might be considered for the bar exam are shown here, with a percentage allocation based on the data that were collected in the surveys. That concludes the walkthrough for the full report. Again, it's long and has a lot of complication, but hopefully we've hit the high points here, and I'm certainly happy to answer questions.
This is Robbie speaking. I just want to say, Dr. Henderson, to you and to Ron, this was really a daunting project. I honestly never knew what the finished product was going to look like, but I think it's very representative of our year of meetings and discussions about this. So I want to thank you for doing such a good job. I think we have some valuable information to present to the court for their review. So I'm very pleased with the way it turned out. So thank you.
Thank you. So not hearing any other questions, then I'd just like to point out that the work that the working group did with us on this, I mean, we met frequently, about every month. And that was, if the study has merit, it's because of the way that you considered all of the various questions and points of consideration that we brought to you and resolved them in ways that made sense. So I want to thank you for that.
Following Jim's presentation, also consistent with the agenda, is switching over to the working group report. And working group report actually covered all of these high points Jim just presented. I prepared a PowerPoint, just a few slides going through some of the key points.
So Ron, I can share that again if you would like.
Sure, yeah, go ahead.
Okay, I'll turn that back on then. Oh, I do it every time. I'm sorry. I need to.
Click on one more button then.
Yep, there's that one last button, and now I can't find it because I'm in display mode. There. Sorry. Well, why isn't it? Let's start over here.
Is it a different one?
So this is, I'm not able to navigate through it for some reason. Ron, I guess maybe you'd better drive.
Okay, all
I'm
right,
sorry.
problem. Give me a minute. Can you all see my PowerPoint slides?
Yes.
I'm not able, this is Greg, I'm not able to see it, but
This is Sylvia. I can see it.
There we go.
And this is not a new material. It's just a quickly going almost to the conclusion of the working group report. If you look at the major headings of the report, you see that we talk about how we collect the data. We looked at all of the indicators on frequency, criticality, and then made a decision to use a composite score as Jim just discussed. And the last two working group meetings actually were focused on interpreting the data and see, based on the ranking of the composite rating, what's the best way of identifying on both domains, the performance to identify competencies and legal topics to identify legal topics as important and frequent based on the composite scale, so that we can say, these are the items that fit into the outline or should be considered for development of the bar exam. So this chart shows the results for legal topics, because we spent 2 working group meetings going through all of the rationales and other factors to determine what's the weight that we should give to the empirical data showing the composite weight as well as other factors. So you can see no one had any issue about the highest one, civil procedure, which according to the composite scale is almost 3 standard deviation away further from the mean. So it's both important and critical based on the survey results. But then when we got to the next one below, professional responsibility, that's where we began to have suggestions about other policy factors or program options that might be more appropriate to pass some of these subjects, because the new attorney requirement that was implemented earlier last year that requires 4 hours of new attorney ethics training. There were suggestions that these might be a better way of testing professional ethics. So going down the list, we ended up with 8 topics. And the 8 topics, according to what Jim also showed, had different ratings on the composite scale. And if we take a step further, those composite rating could be translated into some kind of a weight that could be used in the stage of test development to assign different weights to the different subjects. And if you look at the detail of the working group report, we had covered some of the deliberations about the reasons that we think different subject matters could be tested in other ways, including family law, employment law. These are somewhat highly rated items, but thought that there are other appropriate ways to testing them. Competencies we selected, shown here, 8 competency areas, although 3 of them were determined to be actually belonging to one bundle, which has to do with communicating or working with clients. So from the top, we have drafting and writing, research and litigation, issue spotting. And you notice that throughout interpreting, reviewing the data, that we found a large percentage, more than 50% of new attorneys' time is spent doing research and writing related kind of a work. That shows up also in this high composite rating. Litigation and communication, that can be considered the 2 additional major areas, and as well as counsel and advice beyond that core new attorney activities that were considered to be appropriate for future development of the bar exam to address them in some ways. In terms of the next steps, that's also covered in the working group report. The difference between the decisions or recommendations on legal topics and competencies, the way we see it is legal topics is a direct reflection of the subject matter scope of the current bar exam. Currently, we have 13, and then the recommendations are 8 legal topics. The decision to execute that recommendation appears to be straightforward. It's just instead of a 13, we need to consider how to change it to 8 legal topics. Competency, because the current bar exam, at least the written portion, did not explicitly say what are the different competencies are tested or what's the weight associated with different competencies. And the results from the CAPA study, identifying these competencies, how to actually have them reflected in the test, and the details of the questions would require further evaluation, going into more detail on the tasks and how to create test questions, or even the issue of the best of format in testing different competencies. So these are the major points of the survey results, and then how they translated it into the working group discussions and final recommendations.
Yeah, and it was good. Yeah.
So that's my part of the working group report, highlighted here in these few slides. From here, any questions? If you had a chance to look at the working group report.
Hi, this is Neil. Ron, really excellent job, and kudos to both you and Dr. Henderson for all the work you've done, and kudos to the work group as well. The only thing I noticed, and I did have a chance to quickly go through the report this morning, I think on page 15 there might be a typo. It could be wrong. It's talking about table 4, and then there's a part that says using civil procedure as an illustration of how the competence score works. A review of table 5 shows that entry level. I think that's supposed to be a reference to table 4.
Oh yes, table of reference probably. Yeah, we went through several versions. We'll need to go back to correct any errors and typos.
Okay, that's on page 15. And then
Okay.
the other suggestion I have for that same page is, I know in the text it says what the mean is, and the mean is 10, and that the standard deviation is 5. I think maybe it'd be a good idea to hit it again in the table, in table 4, maybe under the column composite, maybe in parentheses you could put mean 10, standard deviation 5.
Yes.
Just a suggestion.
Ron, this is Emily. How, or Alan or Jim, how would you like us to give you our thoughts on this? Is that the point now where we sort of talk about things like Neil just did? I have a little bit more to go over, but I didn't know if there's a separate point in the meeting to do that.
Yeah, I think I think if you have substantive comments, now is a good time. I have a number of, well, 6 more grammatical or kind of word changes, kind of small stuff that I don't think anybody necessarily be interested in. And I'd like to talk to Eli or Ron or Jim after this meeting. But those are not substantive. So if anybody has any substantive or formatting or anything like that, comments, go ahead. And Emily, go ahead.
I just have a couple. One is, I just think, first of all, thank you all so much. This was just like a lot of work, and obviously the working group has been working on this for, you know, a year and a half, et cetera. And I know you all have been doing the labor's ore to get this all done. I will say that, you know, again, I agree with Greg. I have not had a lot of time to look at this. And so some of this is just coming from off the cuff, and I can, you know, certainly, if I have more time, could be more thoughtful. But the CAPA working group report reads very quantitative, and that's fine because that's the data we have. But I would say that the consensus, or at least majority of the working group members, and how we discussed things and sort of why, for example, you know, administrative law might be important, or why we kept con law in, you know, that's sort of reduced to about half a page. And I am concerned that if this is a final draft, that this is not really a report of the working group, that it's really a report of the statistics that the working group oversaw and gave input to, which I am also fine with. But as far as whether it's a recommendation to make changes based on data and our discussion of that data, this report, to me, it does not have enough of why decisions were made by the working group. For a couple of examples, one is that, excuse me, there's sort of the political side to this, and there's the reality side to this, but I would not have put in the working group report that we want to eliminate professional ethics from the bar exam. Because even though we have said that there are many ways to do that, what's going to be politically seen is that this is a recommendation to eliminate ethics from the bar exam. So it might be that we would have some paragraphs in there about why we think and what we think would be better than actually testing it on the bar exam, rather than just sort of a line in there that says, hey, we're gonna do this in other ways. Another example is that we do address family law in a couple of sentences, but we don't really address administrative law. So I would say that needs to be fixed, period. But if we are in fact going to increase the language in this report to make it a true report of the working group and the discussions that have gone on about the data and not just the data, then I think we also need to have, there's going to be a lot more questions about what administrative law, why that should be tested. So that's just sort of my general overall comment about making this a working group recommendation rather than just sharing data of what we discovered as a working group when we were doing these surveys. So I'll stop there.
Oh, great comments. Thank you. Anybody else on that topic that Emily raised?
So Greg raising his hand.
It's Stephen. I had a different question, which is related to this, and I think helps inform. I did get a chance to read through the report, at least once, carefully. But the part that I'd appreciate your discussion of and a little bit of explanation, because I'm not quite sure I completely grasp it, was the section on the correlation the correlation with the NCBE on the subjects. I'm not sure that I completely grasped that analysis, Ron, and I'd really if you could go through that, I greatly appreciate it.
The correlation has to do with ranking of the legal topics. Starting with the structure of how we created legal topics in the two surveys. In our survey, as you know, we have 19 legal topics, and the 19 expanded it into more than 110 subtopics. The structure of NCB's study is different. Instead of 2 levels, it consists of 76 or so distinct knowledge areas, and not all of them are in the same kind of categories as our 19 legal topics. But regardless, I was able to have a kind of a crosswalk between our 19 in comparison with the 76 from the NCB side. And of course, whatever that's not matched are the ones that's either organized differently in NCB's 76 items, or they belong to something entirely different that we didn't cover or cover in a different way. For example, writing and analysis, those are covered as part of the 76, but those in our survey structure, we can find them in as part of the competency. So to the extent the 2 lists, what we call legal topics and what they call knowledge area, can be compared, the 19 from ours matched to their comparable 19. And in terms of the overall ranking between these two, for example, civil procedure is ranked the highest, and professional ethics also the second or first on theirs. All the way through 19, the way these 19 items are ranked in the 2 survey results are fairly similar with a couple outliers. And that's what that high correlation was showing that I looked at. Quantitatively, it's more than 0.7 from 0 to 1. So that's the evidence that I relied on to make this statement, that the results of the 2 surveys looking at knowledge area or legal topics are fairly comparable in terms of the importance or other indicators used to rate these different items.
I'd like to jump in here. Dean Ferrilla, you're still muted. Did Ron answer your question? Are you ready? Is this
No, Dag, that was helpful. That was really helpful, Ron. And I do see those outliers. Thank you. I might have some more questions later, but that's really helpful for now. Thank you, Dan.
Terrific. So 2 things I wanted to jump in. One, first, just in a moderating capacity, I see that people have found the raise hand options. Terrific. So I'm going to call out names in the order that I saw the hands raised. So it'll be Greg, then Shanae Buffington, and then Jackie. But before you do, I just wanted to respond substantively to the comment that Emily made about the lack of text on rationale for the non-quantitative elements of the report. And you know, I couldn't agree more with your comment. It was something that we really struggled with in reviewing different drafts and not wanting to characterize the deliberations too finely, because I think that those were very nuanced discussions, and there were different opinions. And at the end of the day, some decisions were made, but I think that we felt that would have been a little treacherous in terms of coming up with a report that everyone would think was satisfactory. I would love to, we do have a little time before the report would go, I think next to the committee of bar examiners is where it'll probably land. We do have a little time before that meeting, and I would love to invite a couple of you, if you're willing to draft up some language that we could then use to fill out those sections. And I think that would make it a better report.
Dag, this is Leah. I also, if we have time during the time set aside for this meeting today to flesh some of that out with the whole group, I think that would be valuable as well.
Terrific. So let's put a pin in that, and maybe we can address the members of the working group who have raised hands. And I've got you up on deck, Greg.
Thank you. Can you all hear me?
Yes.
Okay, great. I just want to endorse Emily's comments wholeheartedly. I really realize this is repetitive of what was just said, but I hardly agree. I think that the real judgment of the working group came to the fore in making decisions about what topics to include on the exam or recommend for inclusion on the exam, and the rationale for landing on the 7 topics is really critical, and for excluding the other ones. I think without that explanation of the judgment was exercised, and I think there was consensus on a number of points. I think the working group report really lacks the kind of punch that it needs and credibility, frankly. So, and I'm not, whether you want me to help with the drafting or not, I do have some thoughts. I mean, for example, Steve Frillo pointed out, I think rather eloquently, the importance of real property, even though it was down on the topics, but the nature of real property and rights in law and in American law is really important, and I think that's why it needs to be included. So I endorse Emily's comments wholeheartedly. I have some wordsmithing that I think Alan, I think probably it would be better, the time better spent sending it separately. But as I said, I haven't had a chance to go through the report in the kind of detail I'd like to do. I agree. I was glad to hear Ron's comments about the comparison with the NCBE. I had an opportunity to see the NCB report, and I think Ron's analysis is correct. There was not a lot of difference, substantive difference, I think, in the end between the two. And that shouldn't be surprising, because I don't think the practice law in California, I suspect it's not that much different as in many other places in the country. We all recognize we have special circumstances. I live in a rural state, it's not LA, but the substance of practice law is not all that much different. So I was glad to see frankly, the correlation between the two. I think adds some credibility to the work of the group and those who did the technical work. On the testing of competencies, we had some discussion about that, just some questions about how to do that. And I see that the report says that we should, that's to be further recommendations. I would beef that up a little bit about, why that's the case. We're not making any recommendations on that. I think that's important. I think we had some discussion about it in terms of how do you go about doing that reliably and the like. That was a particular point I made, but I think there was some agreement, including, I think, from you, Dr. Henderson, on the question of reliability. So I would beef up the working groups' own analysis and the judgments executed, made to improve the report. Thank you.
Yeah, let me interject just one thing. I think many of us may have technical comments on, wording and so forth. As I said, let's hold any of those, as Greg has, to the end. And then if people want to drop off at that point, great. And those who want to make the comments for the benefit of the, tidying up the report, we can do it then.
Terrific. Thanks very much, Greg. Are you finished, and can we move to?
Yes, I said thank you. Yes.
Thank you. Shanae Buffington, you would be next in my list.
Okay, good morning. Can everyone hear me?
Yes.
Okay, great. I know Emily had just made a comment on specifically why administrative law, why the group determined that it should be included on the bar exam. Well, the survey findings show that it was a frequently used area of law, and also is not just specific to one area of law. It broadly encompasses FEHA, discrimination, EEO issues, as well as government claims. And then admin proceedings come into play in Superior Court by writ of mandate when agency claims are being reviewed. So it wasn't just like a political move why admin, why the group decided to recommend that it be included on the bar exam. I do agree with Emily as well as Mr. Murphy that we could beef up why we determined some areas to be included on the bar exam. And I know Eli took great notes at the last meeting. So are we just gonna pull from that summation that Eli had taken at the last meeting? And how long do you expect the recommendation part to be? I know it's just like a generally, we should flesh out why we should include certain topics on the exam, but how in depth is it going to be? I guess that's my question.
My sense is that is as yet to be determined, and I think if we go through the different topics as Leah suggested, and determine which additional elements we want to supplement with some more information, and then determine who would be available to assist with that, I think that's when we're going to need to make the decision.
Okay, well, I'm available to assist. I'm just putting it out there now.
Thanks so much.
You're welcome.
And then Dean Gardina, I've got your hand raised here.
Yes, thank you. Again, I want to offer my congratulations for the work that was done in putting the report together. It was, I think, a really great draft and summarized well a lot of the quantitative data. I will be one of the ones that echo Emily and others' endorsement of adding a little bit more of the working group's voice into the report. So available to help if needed. What I wanted to understand, and I know it's part of our agenda, up next, which is the recommendations. And Ron, your last slide included the idea that the competency piece needed to be fleshed out a little bit more in a follow-up. And I'm wondering if the CAPA working group is making recommendations about that follow-up, and that will be incorporated into this working group report.
Donna, do you want to take that? Or do you want me to take a stab at going over what we've talked about?
Yeah, actually, Leah, if you would take a stab at going over what we talked about, that'd be helpful.
All right. So the scope and charge of the working group was to oversee the practice analysis, analyze the data in conjunction with the consultants, and then make, really that was the official charge, didn't include making recommendations, but obviously making recommendations about the results of the data and their implications with respect to the topics and the tasks covered by the bar exam. We have sort of bifurcated that from the next steps more broadly, like a time frame for implementation of the changes, or consideration, formal submission consideration by the court in conjunction with a number of other studies that have been underway. Some of those stemming from the bar exam, the leak of the bar exam topics. We had sort of an audit of our testing administration process done. There have been a number of other studies that have occurred concurrent with CAPA. And so as a staff team, we've come up with an approach where we have identified some recommendations for the board that involve things that could be addressed in the immediate term and things that may need additional consideration by another group. And I think reconfiguration of the entire bar exam to reflect the results of CAPA, for example, is one that would be considered by a subsequent working group, which would be tasked with obviously working very closely with the court to determine if that is in fact the desired approach that we would take, and then the time frame for implementation. It is that group that would then get into issues like how can some of these tasks that have been highlighted as very significant by the practice analysis actually be reliably tested. So we think that getting into sort of the weeds of next steps around implementation, for example, is beyond the scope of this working group. And that for the board and for the court, we on the staff side need to pull together a number of different studies that have taken place over the course of the last year and present more of a comprehensive picture. So that's my long way of saying, Jackie, I think we're looking for recommendations around topics and tasks from the working group. We, of course, don't want to preclude the working group from making other recommendations. And so this meeting is an opportunity for you to come up with those. But we do certainly see it as a sort of staff and me as a consultant now responsibility to come up with a comprehensive package for the board to consider and then ultimately the court.
Thanks, Leah. And just as a quick follow-up, that one of the reasons I raised kind of the scope is on page 4 of the executive summary, there is reference to both the other studies done, and obviously there's even more that you mentioned in your comments. And one of the things that was left out was the most recent March 18th, 2020 report about the simulated impact of the current cut score based on race, ethnicity, gender, et cetera. And then in paragraph 2 on page 4, it does raise questions. Our study does raise questions about the standard setting study. So I didn't know whether it was the scope to also include recommendations about revisiting that, or if that's going to be part of the State Bar's report to the Board of Trustees and the Supreme Court in terms of the impact of this study and how it reflects on some of the other ones done.
Yeah, I don't think we've discussed, we haven't discussed as a team, including in that sort of comprehensive set of studies, that recent analysis that was done around differential pass rates by race based on the cut score. So that's certainly something we can add. With respect to the second issue you raised, I'm sorry, Jackie, I'm blanking on it. What was the second issue you raised?
Yeah, no, on page 4, paragraph 2, it talks about the standard setting study.
Oh, right.
Yep.
Okay, so standard setting. So, so here's the issue with standard setting. If there's a decision to restructure the exam to reduce the topics in accordance with the CAP analysis, for example, and change sort of the relative weighting of the tasks, that will require a new standard setting study to be conducted. So I think the threshold question is the test going to be changed in any significant way? If so, a new standard setting study will need to be conducted. If there's a decision made to stick with the test configuration as it is, there isn't, I don't think, a need to conduct a new standard setting study right now, although we do know best practice suggests that this work is done every 5 to 7 years. So given that the last one was a couple of years ago at most, if there are no changes to the test, I don't see a new standard setting study as being needed. But if there are substantive changes, then of course it would be.
Thanks, Leah. I think the only reason that I raise it is because the State Bar website actually says specifically that a job analysis survey is actually the first step in setting the foundation for validating the licensing exam. And this is the first kind of content validity study that's been done by the State Bar about our exam in particular. So even if the bar exam stays the same, it seems as if the standard setting analysis would need to be done in relation to this study being the relative comparison, not the NCBE content validity study from 2012, which is what the 2017 standard setting study relied on. So just putting it out there that it could be for the State Bar staff to consider whether or not the standard setting study needs to be redone, regardless of whether or not it keeps the exact same State Bar, given that this content study just came up with something different than the NCBE one in 2012.
Yep, that's a fair point. And I don't know, Ron, if you have any thoughts on that. I know we haven't thought about it that way, but it is obviously a valid point.
I think keeping the current configuration, I agree with you, standard setting study from 2 years ago is still a valid standard. But to the extent that we want to incorporate the CAPA recommendation and then make some changes on the subject matter scope, at that point, I think it might merit to reconsider the standard setting, because anytime you change the subject matter scope, Jim, you can correct me if I'm wrong on this. The sequence of looking at standard setting is content validation. If you change it, then you need to follow up with evaluation of the standard.
Right. The normal time frame is that the content validation study, practice analysis, is done about every 5 to 7 years. And because there's a need for currency in the passing standard as well, what typically happens is that when the first versions of a test that are validated against the updated practice analysis are put in place, that a standard setting study is conducted at that time. But it's not a requirement. It's just normal practice, and it is driven, as Ron just said, by the extent of change in the design of the test and the content framework. Some topic areas inherently are more difficult than others, and if you change the emphasis that's given to a really difficult content area, then that could change the level of proficiency that would be required on the test. And so a standard setting study is, really important to do in that event. And then just to keep it current. So it's a matter of judgment. Once the redesign work reaches a point that it's known that some standard setting study is in order.
So again, this is going back to the perspective or larger context that Leah just mentioned. Of all of these different bar exam studies, which one we think is a short-term issue that we can address, which one is something in longer term, and what part of it has to do directly with the CAPA recommendation. All of those needs to be laid out in a very clear plan. And to the extent standard setting is part of the issue, I think it's more a long-term and partly depending on what to do with the CAPA recommendation on the content outline.
So this may be the opportunity where the technology really actually provides us a benefit, because any one of us who is hosting, myself included, could pop up a Word document and we could start like going through the list and just laying it out. Dean Scavaletta, I see that you've got your hand raised. Go ahead.
Yeah, I just based on something Leah said about kind of where we go from here, I'm also wondering, just as a general strategy, about changing some of the language when we say things like the working group therefore recommends these 8 topics. I mean, I think that we have to take in consideration who we're making that recommendation to and what other data they have and other studies they have, such that we may want to say, and again, in terms of our recommendations, sort of, we would recommend the Committee of Bar Examiners look at this. We would recommend, the Supreme Court or whomever is going to be making some of these bigger decisions to do this. I mean, I raise this just because I also think the language in the report is very, kind of cut and dry as far as we make this recommendation. But I think if we have, maybe one of our recommendations is that our work should be the jumping off point, as Jackie sort of said, is to be the jumping off point for another study and, sort of bring in a little bit more of what we know is going on around us. If that makes sense.
I do think it makes sense. Another thing that makes some sense was just suggested to me through the chat feature. As we all adjust this new technology and learn new things, I was on a Zoom meeting the other day where somebody actually took a break. So I was like, oh, you can do that. And I think that we should it was a great suggestion. It allows people to stretch their legs, take care of whatever else they need to take care of. we're about 11 minutes, well, it's 11:20, so that puts us at, an hour, 20 minutes into this meeting. If we took, say, a 9-10 minute break, that would bring us all back at 11:30, if that's okay. And then we could perhaps at the outset of the 11:30 hour jump in with some next steps and discussion of that. I've got a thumbs up. Everybody's using, I love the thumbs up. Thank you, Dean. I got a real thumbs up rather than a virtual one. Okay. And I should have cleared this with the chair first, of course. If there's another element of the technology, is that the people who've got control of the IT have control of the meeting. My apologies, Alan.
No, that's fine. I think it's a good idea.
Right.
Let's do that.
So back at 11:30. I look forward to seeing you all then.
Very good.
touched on legal topics. So will we go into why we also want to include, I think it was communication, counsel, advice?
So yeah, let's start with the topics, because
Okay.
I think the distinction, if I understand it correctly, between the topics and the competencies is there were less policy decisions around the competencies. It was more purely data driven.
Okay.
But let's start with the topics, and I'm going to ask Ron or Dag to share your screen and maybe put up page 15 of the executive report, or another page or graph that clearly shows the weighted scores for the topics.
So I have the report handy and I can do that if nobody else has it handy. But before doing that, I noticed that Ms. Kennedy, you have your hand raised. Oh, you're on mute. Here,
You're
I'll
on
let
mute, Sylvia.
Sorry about that. Not sure if this is the right time, but I just wanted to comment on the report since I hadn't given my 2 cents. One thing that struck me was I remember in participating on the survey and the kind of earlier times that a lot of demographic information was gathered about the applicant pool. I mean the survey pool, and just wanted to know if there had been discussion about the use of all that data. Is it somewhere? How is it going to be used? It just seemed like we gathered a lot of information. Do we know how many, what percentage of the respondents were new attorneys? That kind of information. And is there a place for it? Just seems to me that it might be useful if we're later on, as other committees make decisions about the test and how it affects certain demographics, to kind of know a little bit more about who responded. I'm not sure. I just wanted to make that observation that I think we collected a lot of information about the applicant pool, and I'm not sure how it's being used or if it's being used. That's it. Thanks.
There's extensive coverage of the demographic results in the technical report. In the working group report, the way we came to the decision about first 3 years as representative of entry level, that was based on looking at all of the demographics, including years of experience, as well as practice setting, to see where, in terms of a year's experience, we begin to see differences in the results. So all of those demographic information were used in the analysis and break out the different groups, how they are different in practice settings or practice area. They are covered in the technical report, but not in the working group report. So the details, including all of the appendices, will have those information more maybe as reference, as you said later on. We'll always have those data available.
I think, Ron, we may want to add a table to the executive report, because I do think it's a great point that we want to sort of assure folks of the particularly when we can compare the demographics of the survey respondents to the demographics of the overall attorney population, not just by years in practice, but also in terms of race, ethnicity, gender, geographic distribution. I think we looked at a number of those elements, and maybe a simple table in the executive report illustrating that data would be useful.
My only comment, and I'm sorry to jump in about that, is if we have a table in our working group, we need to address it. I think in some way, I agree. I think having all of that in there is good, but then I think we have to indicate how it may or may not have impacted our ultimate recommendation.
Okay. I don't know that it did. I think what was important was, for example, the question of did the respondents reflect the diversity of the state's attorney population such that it is or is not a diverse group, but did our survey responses reflect that diversity? So it's sort of a validation of the demographic composition of who responded to the survey as compared to the broader population. So I think we could explain that, but that's my understanding of how that was taken into account.
And I'd be fine with that as long as we are explaining that. And it sounds like that's what you're saying as well.
Yeah, that will be the main key point in any survey, to ensure that the sample response that you got is representative of the overall population, which is different than looking into specific demographics to see how they might be doing things differently, which is not the primary focus. The primary focus is to capture data for entry-level attorneys across different practice areas. So getting back to the main topics, Doug, should we just start looking at some of the key topics in legal topics, decisions that we want to flesh out a little bit so that we can make decisions about what to cover now during the couple hours and then what we can address more appropriately after the meeting?
That sounds good. I've shared my screen. I'm pretty sure this is the draft that was submitted to that was submitted to the working group and posted online. And Leah, you'd mentioned page 15, so this looks like where we would want to start digging in.
It may be a different version I was looking at then. I'm looking for there's a table that has all of the topics. I think it's lower. Yeah, this. Because if I'm recalling correctly, our methodology was anything 10 and above is going to be included, 10 and below is going to be excluded, and then in the composite scores. But then the policy decisions came in, and that's what impacted professional responsibility, employment, family law, constitutional law, and real property. And so my suggestion is we focus on those legal topics that deviated from the methodology of the 10.0 and above being included in the exam, because that's where sort of the policy decisions were made. And I think it's, one of the values of this process is that to a large extent, we have let the data drive the results. So I don't feel like the group needs to explain everything, but it does need to explain where there were deviations from the methodology. So that's my suggested approach.
Right, and so doing a little highlighting here, there was, and what I saw in the report was that what we were attempting to emphasize was that there were those areas that fell below the threshold that were added in because they were considered to be foundational to the practice of law. And then there were other areas that, for one reason or another, exceeded the threshold, but that were excluded for, in the area of professional responsibility. I think somewhat differently, it was simply a matter of what the most effective mechanism for testing competence would be. And I agree with the comment that was made earlier that we really need to avoid even suggesting the word drop. The point is not that it's dropped, but rather that it can be tested more. Competence in this area can be tested more effectively with the first year or the new attorney MCLE. So, but for each one of these, it would be terrific to have additional input and additional qualitative information related to how the decision was made and why it was either included or excluded. And I guess, let me add, since nobody jumped in right away, or maybe they were on mute, but I've never been a huge fan of editing in groups. I've generally always struggled when editing to do that as a group affair. I find it much more effective, like getting comments and being able to respond to them in writing. I do see some raised hands. Since I'm in share screen mode, though, I'm struggling actually to get to the raised hands. I think I know how to do it, though. Let me do this.
It's Greg and Jackie.
Terrific.
Yeah, and I agree, Doug. It might be hard to get specific language down, but I think one of the things that was difficult when we were having the meetings, and some of the meetings were done by phone, or people were participating by phone, and it was unclear whether or not we did have consensus around certain items in the particular meeting. So I think it is helpful to go back and reaffirm that the committee is A, comfortable with this, and B, has a general sense of what it is, the reasoning behind it. And I was going to speak specifically to employment law, because I remember it's got a fairly high composite score of 13.2. I think it took everyone by surprise. And I believe it was Robbie who actually teaches, practices employment law. And he's like, that shouldn't be necessarily part of the bar exam. And I think it was Neil's suggestion that I thought was most helpful in moving us from the high composite score to actually making it something that we wouldn't necessarily recommend. And that was a recognition that this was the first content validity study that would be done, that employment law was recognized as something that new attorneys may need to know about, but we felt as if we wanted to kind of check that rather than just jump in. And that one of the things that we might do is include some post-graduate or post-bar exam webinars or online efforts to educate people about employment law rather than jump into adding it to the bar exam. And I know for me that was helpful as both recognizing that it had a high composite score, not adding it immediately to the bar exam because it's so far removed from anything that NCBE or we have recognized before, but C, at least recognizing that the survey did have it high up and providing some basis for new attorneys to need to be exposed to that. So I know for me, that was helpful with the employment law reasoning. And I don't know if others had that same thinking.
And having just suggested that I don't like editing in group, that was actually a very nice, succinct, so now bullet points. I think I missed one of the points here related to Robbie, who has a practitioner thought something. So maybe if I could just ensure that I've captured what you said here, and these obviously wouldn't be the final of what we would do, but these notes would formulate, some pros.
Yeah, and I thought the other piece, and correct me if I'm wrong, but because administrative law was something that ended up being within the composite, and employment law was very much around administrative or intertwined with administrative law, that we also thought the inclusion of administrative law would subsume much of the employment law work that new attorneys needed to know and understand. So I think that was another piece that drew us to move employment law off the list despite the high composite score. And Ron, correct me if I'm wrong, because I'm forgetting the survey piece, but it was employment law. When ESM surveys and others were kind of identifying it, it wasn't always clear whether they were doing employment law or administrative law at the time. And so there might have been some overlap between the answers between those. But I can't quite remember if that's accurate.
I don't think, and I don't remember there was any ambiguity in the survey or response between the two, but there was argument about the overlap conceptually between administrative law and employment. Even some overlap conceptually between employment and contract, because people can make the argument, a valid argument, that employment law to some extent could be covered conceptually under contract. So that was the back and forth in identifying some key legal topics for the content outline. Admin law actually came back after we had our first session. The first session, admin law was not included. Only in the second follow-up meeting that we reevaluated the early decision, admin law came back as considered a little more important or foundational than others.
And if I remember correctly, constitutional law and real property, there were some very strong advocates, and I would let them speak about the foundational aspect of both of those topics as being necessary for any attorney in our system. And then I'm not remembering our family law discussion as clearly, so I would welcome others to jump into bullet point what were some of the motivating factors about family law.
Before we jump to the next topic, could we do these bullet points? I know that one of my bullet points here is incomplete and related to something you'd mentioned about, I think it was Robbie, who as a practitioner thought something in particular. But if this is, if we can finalize this and maybe if this captures most of what you wanted to add, that would be terrific, and then we can move on to the next topic. But I see that there are hands raised, but I can't see who they are. Ron, would you mind moderating?
Yes, Emily, we have three. Let's go in turn. Emily first, Greg, and Dean Frulo raising hands.
So I guess I'm raising a point of order. So am I correct that there's nobody in the working group that is in favor of changing any of our actual recommendations on the legal topics? Like, we are good with the subjects that we have said should be tested on the bar exam. And I would just say, if you do object, you should tell us soon, because what it sounds like we're doing is going through and really indicating why we made the decisions we made, which is great. I would also just say that, you know, like Shanae had brought up admin law, and obviously, you know, I am a huge proponent of admin law as well, but it might be that if we need, you know, different people to write different pieces of this, that the people that sort of have the reasoning and same with family law, why admin law, why family law was not what we just did with employment law, that could be done after this meeting if we need to continue to do it, but we may want to see who would be available to do that. So that's my point of order, is just to maybe collect people that are interested in talking about why it was in or why it was out. And then the other thing I just would say is that if we can also put in there that maybe I mean, we didn't agree on everything, right? So, you know, we sort of looked at the data and we also had some discussions, but I think there were people that would say, well, we really still think, you know, employment law should be in, or we really still think professional responsibility should be in. And maybe there are some ways that we can say that, you know, the majority of the working group, here was the minority view, et cetera, just so that the state bar understands that we considered the other side as well, but ultimately came up with that. And again, I'm happy to help draft or do whatever.
So I think your point of order is especially, I think that's super useful. The question as to what, it is the threshold question. Are we good with the proposed decisions? And we are simply moving on to solidifying the language that provides the rationale and making sure that that's as complete as possible. And the final point that you raised, Dean Scivoletto, related to ensuring that also the where there was a lack of consensus, that is captured in the report as well.
Well, we had the discussion twice.
Or is it?
So what was the order that you proposed in terms of raised hands, Ron? Was it Greg Murphy first?
Yes.
Oh, thank you. I noticed with respect, well, my recollection is that the overarching rationale for reducing the number of topics into the topics we have is not just what the data was, but the judgments exercise that these were foundational topics that every lawyer should have in California in order to be able to be to practice law competently. And so that's why, for example, constitutional law was added in, because even though it didn't reach the 10 threshold, it was still thought to be by the group as a matter of judgment, it ought to be included. We had pretty much, well, as I recall, we had a consensus in December that it was going to be the 7 topics, and then for whatever reason we in January revisited it and admin law was added. I think there's some other considerations to take into account. I might actually do a minority report on admin law, although I certainly acknowledge that I agree that I think that's an appropriate a topic in California, the administrative state and all and the like. But this gets into some of the nuances that Dag referred to earlier. But I think that the overarching rationale again was the foundational topics that all lawyers should know. And addressing the professional responsibility piece, I noticed in the executive summary it said, well, we think that's better to be better taken care of in a CLE after the first year or during the first year of practice. I recall that there was discussion as well. We're still using the California is still using the multi-state professional responsibility examination, and it's okay in that context to continue to use that. I don't know if you want to add that in or not, but it seems to me that was part of the factor of the discussion, because I certainly agree with Emily that without a rationale for professional responsibility more than we have, that's going to raise some eyebrows and some serious questions, because no one can seriously argue that a knowledge of the professional rules isn't important to the practice of law. So I would add in it's being tested. I don't know if there was consensus that we should just leave that for the year of first year practice. And then on the employment law, I certainly agree with what Ron said, that it was, one of the thought was that employment law is really an amalgam of contract law and in California administrative law. So those are the 2 big factors, as I recall, in addition to the fact in addition to the foundational topics, which I think there was pretty much a consensus on them. Business associations, there was a significant thought. I remember that that's pretty foundational too, but ultimately, I guess there was a maybe grudging acceptance that maybe that could be wasn't so foundational to practice. So I would beef up the rationale for why the ones that didn't meet the 10 threshold that were included are included, and why others that met the threshold were reduced. But I just don't know that offering specific language in this format on a Zoom meeting is going to be very productive. Thank you.
Dean Ferrullo.
I think someone made the comment that in the background that we spent 2 long meetings on this, and I'm going to go back and review those. But I think it's good to remember the reasons why we came to the conclusions that we did, and I think that people have done a really good job, articulating them. I agree with Greg. I think very, very important consideration for professional responsibility is the fact that there is the MPRE, so that subject is specifically already tested. I think the discussion of employment law is along the lines that we discussed, the combination of administrative law and contracts. I think that we talked about business administrations going at this in connection with employment for some of the same reasons. And then the only other comment is on constitutional law and real property. I mean, I think that I would just slightly tweak the language and just basically say that I'm looking at the language as this: knowledge is fundamental for understanding the legal system, rather than the language there is now core knowledge for the legal profession. I think it's core knowledge for understanding the legal system. I think that's really the concept that we talked about. And then finally, I think the discussion of employment law was consistent with my recollection of the things that we discussed. So it's just a summary. I think where people's memories are good, and it's nice to just to talk some of these through. I think it's really valuable. So thanks to everybody.
Can I ask a quick question? Does the group feel that the elimination of or the inclusion of admin law is actually related to the decision to exclude employment law? Because admin law was within the top 10, right? And then there's this connection or correlation between the topic areas. But would it be too far for us to include that directly in the report?
I don't know if you want us to answer, or we need to raise our hand, or.
Yeah.
Just go ahead and answer.
I would just say that I was unfortunately not on the conversation about admin law, but I would absolutely add admin law independent from employment law. The administrative law, especially in California, it is all encompassing our court system, our administrative, obviously our administrative systems and law judges. So for California, absolutely, I mean, it probably makes sense for other states, but it absolutely makes sense to test. I think the issue that we may want to think about, but again, this is getting to how we test, is that the NCBE does not think that it is important, and it is, or not as important. And so if we want in the recommendations to have a discussion about sort of how it was added, which I cannot speak to, but somebody else, not me, can, but also speak to the importance of administrative law specifically in California, which I think Shanae was getting to earlier. I would just say for me, it's absolutely independent of employment law. And I practiced employment law for 8 years, and I do know kind of all that is weaved into employment law. I still think administrative law is what would be better tested for the number of attorneys that are working in that field.
Mm-hmm. And then this is Shanae. I just want to follow up with Emily's point. I'm looking on page 21 of the report, and it says administrative law in regulatory practice. The NCB ranking, the mean importance is 32, and the CAPA composite ranking is 9. So I don't know if maybe Ron or Dr. Henderson can speak to that. It looks like from what I'm looking up to page 21, that NCB ranked admin law pretty up there, pretty high.
Relatively, the CAPA ranking of admin law is higher than in NCBE.
Okay.
And that's similar in the opposite direction of a higher rating of business association and uniform commercial code in NCBE compared to CAPA. So these are the few of the areas where they are not aligned as closely as the others.
And then maybe it's just because state law, states handle admin practice and procedure differently. So then maybe I'm assuming that's maybe why it wasn't ranked as high for the NCBE.
I just want to clarify, Dag, I did not say that an administrative law and employment law would both be valuable to include. Thank you.
In the follow-up session to reevaluate the decisions on legal topics, actually, we went through a process of comparing pairs of legal topics to see if we had to make a selection comparing 2 different topics, which one we would choose. And so going around, I think at that point, the difference between admin law and employment law, despite the higher ranking for employment law, where there's some overall consensus about admin law being more important than employment law because of other considerations.
Ron, I would express that a little bit differently. I think administrative law encompasses in California a lot of employment law.
Mm-hmm.
And I think that was the discussion. And then as you so correctly pointed out earlier, that, then there's contracts. You know, I just, the course that I'm teaching this semester on in-house corporate counseling, where we try to give people who are going in-house a basic understanding of the areas of law that would be important to their practice if they go in-house. You know, we do spend time on employment law, and the two things that we talk about are basic sort of employment contracts, but then the other, you know, that modify the at-will relationship in California, and the rest of it's all about the DFEH, right? And other administrative procedures and how they differ from procedures elsewhere. So, I mean, I think it's that administrative law encompasses a significant amount of employment law here in California.
Sounds like one we haven't touched. I don't know if people have their hand raised. I'm sorry, I can't see that. Are there other people? Ron?
Yeah.
There aren't.
Yeah, I
No.
had my hand
Okay,
raised.
I'll raise my.
It's just we're talking about the particular topics, but it wasn't just that we made a policy decision around topics. We actually reduced the number of topics that we're recommending are tested from 13 to 5. We could have included 13 topics, but we chose not to, and in fact reduced it down to 8. It seems important to not ignore that decision in the report.
Yeah, my recollection is there was consensus that the bar exam really needs to be composed of the most foundational topics. And that's reflected by the data and the judgment of the group in the report.
I think part of the other reason that we felt that testing 14 topics or whatever it is was at least unnecessary in this particular format is that we were really testing the same skills. We were testing legal analysis and, you know, writing and application of facts to law, but we wanted to be able to get the foundation with the legal topics, but also ensure that a lot of the other components of being an attorney are being tested in some way as well.
Yeah, I certainly agree with that, Emily. Very well said.
Leah, I believe you were next.
All right, I'm unmuted. I was just going to say we haven't addressed, I don't think, family law. So I wanted to pitch that one out there and then go into maybe a little bit more about this decision to reduce the number of topics, sort of separate and distinct from using the data to tell us which topics we should include. But could we hear a little bit more about family law?
Here's what we currently have in the draft regarding family law. The very short statement here.
I recall family law, employment law, and business associations were 3 of the topics that people recommended searching for ways to test outside of the bar exam because they were important, but not necessarily the foundation. If anybody recalls differently, please interject here. So family law, business associations, and employment were the 3 that were deemed to be important, but more focused than foundational.
It's business associations and employment. Okay.
And I believe the conversations were surrounding, people didn't have specify, but it was, correct me if I'm wrong, we recommended looking for ways to test it in a first year exam or in some sort of way outside of the bar exam, but maybe make it a specialization if they're not already specializations, or sort of for the recommendation.
I don't. This is Greg. I don't recall being an issue of testing. It was just that there are other ways to assure some familiarity with it. For example, a CLE program, or like I don't recall specific recommendations regarding testing those areas outside the bar exam. Maybe I'm wrong on that. My memory is that it was in addition to the not necessarily the foundational aspect of it, but there are other ways to assure some familiarity with the law, whether it be a CLE or a course in law school and the like.
Thank you.
Yeah, for example, in business association, I think there was some thought that as a requirement of licensing, one would have to demonstrate that one did take and pass a business association course in law school. There was some discussion. I don't know. There's consensus on that, but there was some thought about that's how we would recommend that be assessed, either in law school or in a CLE after law school. But I'm not sure any particular CLE can do all that a course of, full semester long course can do.
Going through all of these factors, I think it's consistent with the narrative or the logic that we put into the working group report, which is that we started out looking at the data, so the decision-making process and the discussions were driven largely or in important part by what the data shows, but also other policy considerations. One of the things, as many of you have pointed out, later on, Robbie also emphasized, is the number of subject matters covered. There is a consensus that instead of 13, we need to use the data to look at a more foundational core set of legal topics. So that was the decision, moving from 13 to, I don't know whether 10 or 8, but ultimately was based on the data and other policy considerations. That's where some of the deviations from the threshold that we were able to come to a consensus. And that consensus is at a second level is driven by the distinction between something that's foundational or core and others that's more practice oriented or specialization related that could be bolstered by CLE or some other means rather than being part of the test.
Yeah, another thought was that if one had competencies in those 8 topics or 7 topics, 7, 8 topics, then one probably had the skills to then become competent in the other areas. Even though a general license is given, we're not going to test all areas of law people practice. We're just going to test the areas that are so foundational that one could become competent in the other areas.
Dean Scivoletto, I noticed you had your hand raised, but then it got lowered.
Yeah, I decided, I'll just say it really quick, but there are a couple of things like remedies and trusts, wills, where there is some bleed over in the questions that are asked on the multi-state, the MBEs, where if you're studying contracts, there's a little bit of remedies in there. And if you're studying property, there's a little bit of remedies in there as well. And sometimes a little bit of trust wills in contracts. So I don't know that we'll need to address this, but I think the other subjects that we have said we don't need to include, and I think people would very much say remedies is hugely foundational, but I think we can say that remedies can be tested through these other subjects, right? So I just think we may want to have some thought about like other responses we may get when people say, well, how can you say this isn't foundational? We just need to know that some of that is already captured in what we're suggesting that we keep.
The test specifications can handle.
The decision on remedy came earlier. It's not reflected in the survey results because it was at the time when we're trying to lay out the structure of the survey, creating, starting with 13 and then later on expanded to 19 legal topics. Remedy was considered to can be addressed as part of the another legal topics. Was it torts or some other area legally? So that was what affected the decision on remedies. Leah, you had your hands, and Ellen, I see also.
Yep.
No, I think that was an old hand raise. I guess without entering into a painful discussion, though, I do think it would be helpful for us in working on the next draft of this to really understand if the group sees that there was a separate and distinct decision to reduce the number of topics, period. And then once that decision was made, there was a review of the data to determine what topics would be included in the exam. Because I'm hearing that perhaps from Jackie's comment that there was some intentionality from the outset that the number of topics would be reduced, sort of regardless of what the data said. But I just want to make sure that we're getting that correctly from the working group's perspective.
My recollection is that there was a general consensus that perhaps the number of topics could be reduced, but that there was, but I don't think that decision was made until we actually got to look at the data.
My recollection's a little different. I seem to remember that there was a pretty strong argument, and I've forgotten where it came from, that there were too many topics on the exam, and that we should be trying to get it down to more in the 8 range. And the reason I raised my hand was, I think Emily's point about remedies as a bleed over into other areas is something that should be footnoted, at least in this report, because it's an important topic for future consideration. And since we may not have this cast of people in the next group, we shouldn't lose that thought.
Although I'm no longer sharing my screen, I've got those comments.
And going back to the issue of the number of topics that Leah said, to what extent do we actually raise that as a specific point as a decision rule to consider? My recollection is after the results from the survey came out, it became very clear the distribution of legal topics is dominated by a few. And regardless of whatever factors people were considering in evaluating the appropriate number of topics covered on the bar exam, we were at that point moving also based on the survey result to a consensus about the need to reduce the number of legal topics covered on the bar exam. And after going through several meetings, that consensus became stronger, especially when we're trying to go through individual legal topics to identify the priority of them.
Looking at raised hands, I see. I don't know which order they came up in, but maybe start with Neil, and then Dean Ferrullo. Neil, you're on mute.
Hold on a second. Now?
Yeah, we can hear now. Yes.
Okay, great. Sorry about that. And it took me a while to figure out how to raise my hand, so apologize for that delay as well. So I was getting a little confused here because, there's two different questions here. Are we testing topics such that we are confident that the examinee, if this person passes the exam, is just generally competent to be a lawyer? Or are we testing to make sure that the attorney is competent to practice law in California? And I think that's an important difference. And so, and I'll also point out that a task force out of New York State just came back with its final report earlier this month. Some of you may have seen it. And that task force was supposed to review how the UBE was being implemented in the state, and also how the New York specific component was testing examinees. And that report was pretty critical of both the state's reliance on the UBE and whether or not the exam was properly preparing attorneys for practicing New York law in New York State. So I'm just throwing this out to the group. Which question are we answering? I thought our role was to answer what is, what test can we put out that measures the competency of an attorney to practice California law. So if that's what we're focusing on, I think we have different questions about what should be what should be topics, what should not be topics. But if we're answering the other question I posed earlier, then that seems a different analysis of the topics.
Are you saying, Neil, then that, for example, you think the decision to not include employment law should be revisited?
Well, I think part of what my initial thought was is to simply flag it and look at it a little bit further, right? With the eye that, because it seemed like at the time we weren't entirely sure exactly what that meant. So whereas here now, we seem to be talking about, okay, well, maybe let's bring remedies back onto the table, which seems to be more like a discussion about just general testing about competency. And if there are California specific things, well, as long as we test these core topics, then we're confident that these attorneys can catch up. What I saw in the New York Task Force report was a sizable concern that, albeit anecdotal, from a lot of different judges and senior partners saying that these attorneys coming out of the New York bar exam were just not ready to practice New York law.
This is Robbie. Going to Leah's question, I want to echo what Alan said. I think that at the outset, there was a consensus that we were going to be talking about reducing the number of topics on the bar exam. I kind of remember that being one of our fundamental premises going forward. And after we saw the data, we started looking at the specific topics. And as you know, I do practice employment law, and I was one of the ones that said that did not need to be specifically on the exam because it wasn't as foundational as other topics. Now, going to what Neil said, I honestly don't recall our emphasis being on California law per se. I think we were looking at fundamental topics that address minimum competence to practice law. We took family law out, which is, one of the topics that's unique to our and just a handful of other states. So, Neil, if you think that is a more appropriate emphasis, we might want to take another look. But I don't think that's the direction anyone on the committee was going, as that New York study suggests. At least that's what I recall. I don't know, Alan, if you have a different recollection.
If I can interject, I can add here that was partly addressed when we were going through the exercise of refining the construct statement. The construct statement is related to the question of what exactly is the expected minimum competence of an attorney that where you're trying to use the data to define. So through that exercise, I think we largely addressed the issue of what we're testing.
It's Stephen. I just want to say, my hand's been up for a while. I agree with what Robbie said. I think it's a slightly different dimension from this. I don't see it as cut. I think pedagogically and exam-wise, I think there was an argument for cutting the number of subjects on the California bar exam. But I want to put that aside. It seems to me that if we look at our study, okay, and you look at the data that we got, and this is Robbie's point, you look at the data we got early on, there's a reasonable argument that if you wanted to test competencies in California in practice areas, that the number of subjects on the bar exam should be doubled. That it should be 20, okay? And I think we all agreed that that didn't make any sense, okay? Because in a sense, what we were doing, as Emily pointed out so well, is that meant that we were just testing different skills, legal skills, core legal skills in just different ways with different subjects, okay?
Mm-hmm.
And so that led to the view, okay, let's get to some core number of subjects that test skills across competencies, right? So, because again, I think what that study showed early on that was just so compelling in it is the wide variety of practices, the wide variety of knowledge areas in California. And there's no exam, okay, one exam that could test across all of those things, okay, in terms of what broad number of subjects would have to be tested. That is just not practicable. So it wasn't just say, well, we have 13, we need to cut back to 8. It would say basically as an argument, if you that the basis on which you had 13, that it should be 20 or some number like that. So.
Dag?
Yes.
Alan, I'm going to interject here that it's 12:30 and I don't have a firm grasp on how much longer you think we're going to be going, but I would defer to you, Leah and Ron, and perhaps Jim to give us some guidance here. If you think that we've got more than half an hour or so of remaining work, I think we should take a lunch break because nobody functions well with long and no breaks. But if you think we can conclude this in about a half an hour, then I think probably we'd all just as soon get off by around 1 o'clock. But again, we need to make that go, no go decision now.
So I'm seeing some input suggesting that we take a 30-minute break and we come back at 1. I see 2 raised hands, Robbie, and I don't know if you still had your hand up, Dean Ferrula. That was from previously.
Mine was from before, so I'm fine with the break. I'm fine with going forward if we're going to be able to complete within the hour. Alan, that's your call.
Yeah, with attorneys, time estimates are very flexible, so I'm a little skeptical. Say an hour, it'll be an hour, but I'm willing to go with the group consensus. But I think if we're looking for a decision, we ought to make it now. And if we think it's going to be over about a half an hour, given the time elasticity, I think we probably ought to take a break. Dave, you, Leah, what do you think? Are you seeing a consensus for taking the break, Dag?
I'd like to have Leah speak to this.
Yeah, I personally think we should take the break, and as a staff team, we should use that time to have a quick call so that when we come back, we use our time really efficiently. But I do think this is our last meeting. We have it on your calendar, so I think it would be valuable to just use as much time as is needed without killing you. to try to work through some of this, because
Okay, so it's 12:30. Let's come back at 1 o'clock. Let's reconvene at 1 o'clock.
all right, thank you.
All right, great. Thanks, Lee.
Okay. So Leah, so I'm gonna get staff together and send out a quick, what else? A Zoom link.
Right.
Although, you know what, that might require that our hosts drop off. So I'm gonna send out a conference call line to staff so that we can do a quick conference call.
Okay.
Okay, see you in a while. We call back on the same Zoom meeting
Yes.
number.
Yes,
Okay,
it's the same,
thanks,
same
Rob.
link. Yeah, thank you. Ellen, I think everyone is back and ready to get started again. I'm muting. You're on mute now. Let me see whether. Oh, you are.
1 o'clock. Let's roll. That's good.
So welcome back, everyone. We try to use 1 hour or 2 to finish up and addressing the issues that came up. That can be grouped into several areas. One is to get consensus about the legal topics, that everyone had different views in different areas, but overall, going through the several meetings, there's a largely a consensus on those 8 topics. We want to reconfirm that's the decision from the working group, although some of the areas that we need to go back to the report to call out and make sure that we cover all of the different views. The other is following the legal topics, we want to also have some reaffirmation of the decisions on the competencies, the decisions that we made on the competencies. And then any other thoughts you have about those 2 major areas in the study and leading to very important recommendations about the studies. And after going through all of these, we would like 2 volunteers to work with us to finalize the report. And after finalizing that report by incorporating all of your comments, another question is whether you think that a decision that we need to make is whether after finalizing the report again, there will be a need to reconvene to review the report, or you want to just delegate the decision for finalizing that report to the two volunteers, though you would have definitely an opportunity to look at the final version of the report. So those are the items that I hope we'll be able to take care in the remaining 1 hour or two. So should we start back with the legal topics?
This is Robbie. I guess I just want to take one moment to highlight what I was saying just before we took our break, which is at the outset, and I guess this goes to that New York study that Neil referenced, which frankly I'm not buying it, I suppose. When we first got together, I think we looked at minimum competence, what kind of things should be in the bar, and I think we all agreed that fundamental topics that test the kinds of core things we were looking at, issue spotting, analysis, were what was going to be our focus. And the discussion today kind of highlights the fact that we didn't always agree on what those topics were.
Anyway, she knows.
But we did come down to, I suppose, a consensus at the end. And I think what I want to make sure is my view is that if we've got the right topic, the right subject matter, we're testing a new attorney's ability to adapt to any other topic. I am an administrative law judge in employment law. I had never approached that area of law until I was hired by the state. But it was my ability to do the kind of things that we're testing in other areas that I think made me a good candidate for this job. So I don't know, Neil, unless that is a direction you want us to look. I'm not bothered by anyone that might say, well, this doesn't prepare someone to practice law in California, because I think it does. I think there's a lot of value to what we've done in terms of looking at the kinds of topics that are going to result in the sort of issue spotting and analysis that makes for a competent lawyer. And of course, we have a lot of plan Bs of classes that we're going to maybe require in law school or require in MCLE format to pick up some of those other areas. But I just want to make sure that all of us were on the same track about what our goal was and how we got where we are. Alan?
Yeah.
I always come back to Alan in these matters.
No, I agree with you. First of all, I think that the distinction between preparing for practice of law in California and preparing for the practice of law everywhere, there might be, some slight distinctions here and there, but I think there's so much in common that we really don't have to spend a lot of time worrying about that particular difference. Yes, we are concerned about public protection in California for sure, but I think preparing students and testing students to a general level of competence in practicing law is sufficient to protect the people of California. And second, and admittedly secondary, I do think that our law students should be accepted and equipped to practice law in other jurisdictions as well.
And Neil, are you back on?
Yeah, no, yeah, I'm back on, yeah. Well, I don't know, I'm still just a little confused, because then why did we bother to do these surveys asking attorneys what kind of law they're practicing? And why did we ask them of only California attorneys? Why didn't we just limit it to core, the topics that we think are testable core competency topics? Why did the NCBE do the same thing? And if there's already another exam out there that tests things like con law, property, contracts, well, then why don't we just switch to the UBE? So I thought we were trying to do something a little more nuanced, but again, that's just me.
But Neil, this is Leah. I think we were, and I guess what I'm struggling with is, are you sort of taking issue with the ultimate recommendations now because you're concerned that they don't reflect what the data's told us about California attorneys because there's been too many policy decisions to move away from what the data said? I guess I'm trying to figure out how to sort of actualize or operationalize the comments that you're making.
Yeah, I think I don't know. I'm just opening it up for discussion because unfortunately I wasn't involved in the set of CAPA meetings that decided the scope of the study and what questions should be asked. So I don't know. I wasn't part of those discussions. So I guess maybe that's part of my confusion. But I mean, I'm just raising the question about whether or not. I mean, why did we survey these things then? If we thought that there are core competencies that could just simply be tested to test an attorney's competency, we could have simply just left it at those topics. So I'm just confused, and I'm also confused why NCBE is doing something similar too, because aren't they trying to rejigger maybe what attorneys across the country predominantly practice? Just a question I have.
Well, this is Greg. With respect to NCB, I think it's good psychometric practice to do a job analysis on a periodic basis. And since the last one was done in 2012, it was time for another one to be done. So that's the quick answer why the NCB did it. And I just recall lengthy discussions over a course of meetings about whether it was appropriate to test on the idiosyncrasies of California law or to test whether people can think like lawyers, and that is fundamentally comes out of the basic canon of the topics that we've come up with. That was my overall recollection of how things went during the meetings.
And Neil, to give you more background about why we do our study, it's an extension or a follow-up on the content validation study. In that study, even though we were satisfied with the results, but part of the limitation was we want to make sure the basis for doing that study instead of a 2012 NCB study, not only because it's some time ago, but also it's national. It didn't cover any California specific topics. And the results of this current study, it's a validation of some of the major legal topics that's not only important as a matter of practice, but also consistent with what's considered the core foundational knowledge. And what's considered a core foundational knowledge, NCBE's 2012 study actually highlighted civil procedure. Prior to that, before 2015, civil procedure was not part of the content. And it's only through a practice analysis study some of what's considered the core knowledge were validated and actually added to the exam content outline. So I'm not sure I answered all of these background information addressed to your concern.
No, thanks for that, Ron. But I'm just, again, raising the question. So, I mean, if we're doing if this is part of doing a validation study, and it's showing that real property, both at the national level to some degree, more so in California, is not as, widely practiced as it used to be, then why are we putting it back into the mix? And not replacing it with another topic that is that our study shows has a much higher rate of being practiced.
Stephen Farrell had the best, I thought, analysis of why real property should be in. And
No, I mean, again, I'm glad to address it again. I mean, there are areas of legal specialization, and there are lots of them. Okay, and nobody that I know is an expert in all of those areas. But there are things that are common, okay, to the Anglo-American common law legal system that are the foundations of it. And if you don't understand those foundations, you don't have the fundamental understanding of the legal system. And we've talked about this before, okay? The common law very much grew up as property rights. That's the fundamental concept of real property. So yes, people don't practice. As many people practice in the area of real property, but real property is foundational to understanding how the Anglo-American common law legal system works. So then by analogy, you could say, the other subject that falls below the line was constitutional law. And I don't know, someone who worked for the Supreme Court saying that we ought not to study constitutional law because a lot of people don't practice it, which is true. I think belies the question of, in fact, that we have a constitutional law system which constitutions, both the federal and the state level, are also fundamental and foundational in the impact of a written constitution. So I think that that's where I think this group, in extensive discussions, has made arguments based on fundamentally based on the data that we saw, but then made these policy decisions based on really our collective experiences, people who practiced and taught and judged the law. And I think that's been a really good discussion. And I think it's answered these questions.
To echo Jim Farollo's description about the role of real property, that reflects in my view, as the overall decision-making process, which is not only consider the empirical data that tells us what the practices are like out there, but also consider other policy factors. It's similar to if you look at the content of a high school curriculum, you want to say what's important. Geometry, probably everyone would agree, is more theoretical. It doesn't have as much practical value as, say, something similar in mathematics, statistics. The result of it is you want to cover some balance of what's considered foundational theoretical and practical knowledge. And that I would describe is a similar kind of a balance in our decision-making process using data as well as policy considerations.
Neil, you asked about, why not go to the UB? I'm not going to do a commercial for the uniform bar exam, but I just note there would be significant advantages for the applicants in California who are not able to meet your minimum passing score. If they had the UB, they could transfer it elsewhere and be admitted. And there's, you can go different ways on the argument. Do we want this test on California law, or do we want to test general capability and competency? And 37 other jurisdictions have decided that you can go with uniform bar exam, and maybe those 37 are wrong, but maybe it's like France, 40 million Frenchmen can't be wrong. So, and women.
And this is Donna. I would note that at one of the early meetings of this group, probably at several meetings of this group, the question had come up about the fact that NCBE was doing a job analysis and we were doing a job analysis. And, one of the things that I know I had said several times was, we are going to let the results of this job analysis speak, and the work that you all were doing, all the members of the working group were doing to interpret that job analysis. And one of the things that, that the results of the two different job analyses could tell us is that the practice of law or the requirements for entry-level attorneys in California potentially was not significantly different than the knowledge, skills, and abilities that are required of entry-level attorneys nationally. And if that proved to be the case from the data, then it would be a valid discussion topic for the follow-up committee to this group, for the board and others to be questioning whether or not a move to the UBE might make some sense. And so that was always something that was sort of a possibility for discussion, depending on what the results of the California job analysis and the NCP's job analysis look like.
So within that context, the context of a larger policy considerations and thinking about what we need to do within the scope of the CAPIT study, especially for today, I'll still go back to what I just mentioned after the break. What we need to accomplish is to reconfirm the decisions that we have made about legal topics and competencies. If there are any concerns, we should raise them now. And also later on when we incorporate your additional feedback into the final report, we want to make sure that they are covered, they're addressed in the final report. So at this point, for sake of efficiency, maybe it's easier just for everyone to think about, again, their views about the decision on those 8 legal topics first. If you have any concerns or objections about going forward with that decision made several months ago, please raise them now so that we can move on to the next one, which is competency, and try to finalize the report.
Well,
go ahead.
Just briefly, I thought Emily made a good point just now, and it's not just the question of those topics. It's, you know, what do you trade off if you don't go with the UBE, if you just go, California goes its own way and does its own exam. And there is some merit to considering the question, but that's a larger policy question that I think is probably beyond this group unless we want to make a recommendation, but that's gonna be a whole nother discussion. So, you know, I'll just note that we had come to a consensus in December. There was gonna be the 7 topics. They just so happen to be the 7 topics of the MBE. I'm not even sure where the NCB is going to go with this test as a result of its, you know, analysis. So, you know, there are some differences, and I don't have in front of me the specific topic area, but you know, they're the larger policy questions that I think is probably beyond the scope of this group.
And Ron, this is Jackie. Just to be clear, I mean, what we are doing is making a recommendation in a vacuum in some sense, because if the next step of this process is for the State Bar and the Supreme Court to determine whether or not we should keep the bar exam as it currently exists, whether or not to change the content of the bar exam, and potentially the format of the bar exam, it seems like if they choose to keep the bar exam as it currently exists, then these recommendations are just that, recommendations that were ignored. If they move to change content and format, then these recommendations are just that, recommendations that I'm assuming the next iteration in this process could review and look at the data just like we did. Is that accurate?
In terms of the sequence of the decisions and considering different aspects of the bar exam, it is accurate, but I wouldn't characterize it as our recommendation being made in a vacuum, because it's consistent with the scope of the project. The charge of this project is to conduct a study and use the study results to make decisions about what should be considered as the bar exam content outline. How to actually execute that result, which is the outline of the bar exam that we can recommend from the study. That's the next step, as both Donna and Leah talked about, a next group that would take up that recommendation. So what we are doing is providing a foundation for the next series of decisions. Those are policy decisions, but our results so far as I can see, whether the data or the decision-making process has been unambiguous in terms of the outline of the bar exam.
Yeah, and excuse me if I'm not using language well. I think the part, and Greg Murphy raised this several times during the process, which is we were, I think, making policy decisions based on certain assumptions. For example, if California was going to move in a completely different direction, not use the MBE, create their own kind of exam that reflected the content, this group may make different policy decisions than it did versus the policy decisions we're making, I think, based on the underlying foundation of we'll have a day of MBE and a day of SAPT exams. And I think I go back to agreeing with Neil that my understanding that we were tasked with was figuring out minimal competence for the practice of law in California, because our content analysis job study went to the California portion of the exam versus the MBE portion of the exam. If that exam is going to be blown up and something new and different is going to be put in its place, would the committee have come up with a different set of recommendations based on what it saw? I don't know the answer to that. So when I said in a vacuum, I think I meant in the context of some assumptions about what the testing format would look like, and an assumption about the MBE still being in place.
So again, going back to the question of the scope of campus study.
I'm sorry, oh, we have a couple raised hands, I think, Ron.
Yeah. Let me see how many.
I'll raise mine.
Neil, Emily, and Leah. Okay. Yeah, that's it. Let's go in that order. Neil first, Emily, and Leah.
My hand was raised from previously, so you can cancel me off.
Okay. Emily?
I just wanted to kind of just focus for 1 second on what Jackie had mentioned, because I don't know that it was my understanding that I thought we were going to keep the same format of the exam from the beginning. Because we had talked about the fact that we really shouldn't think about that there might be, we've given advice here and there that's not necessarily reflected in the report because it's not our charge about how we think something could be tested. But I think ultimately, at least in my mind, and maybe others, the idea was not to think how to test yet. And I think Jim had mentioned that too, is just thinking about all things being equal, what does minimum competency mean? And then what are the legal topics, legal skills, areas of practice that we felt were important in order to assure minimum competency? But maybe I'm not, and I just wanted to clarify, maybe I'm not understanding, Jackie, because I think there's a different vacuum. But just because I think we have all of these other working groups and tests and surveys and all of that that are kind of coming together, understandably, for somebody, not us, to review. But I just wanted to clarify, I'm not necessarily saying that, yes, these are the 8 topics because we have the same bar exam we have.
Yeah.
Oh, that's what I was going to ask. I just wanted to follow up on Jackie's comment and see where others were, because I too didn't think there was a presumption that we were keeping the MBE. I didn't think that was part of sort of the basic, not that we talked about getting rid of it either, but I think it was agnostic to that point. So I just wanted to follow up on that as well.
In a sense, I also agree, or I can see the point about your saying that we are making decision in the vacuum. It's partly related to the context or sequence of making these series of decisions. What we are studying is providing, following the standard procedure of exam development, we're providing a blueprint. And after blueprint specifying what needs to be covered, the next step is to determine what's the best way of testing them. That's when we get to the question of test format and test specification. So again, we are making a foundational decision about what needs to be covered. It's the content validation. Now that I think there's no objection or going back to revisit the decisions about the 8 legal topics that we have made, I would propose that we move on to the competency decisions that we have came to in the same meeting after we have completed an evaluation of the legal topics. Let me see if I can go back to the report. So here, everyone can see my screen. I'm sharing the list of the competency areas. This is composite scores for the legal topics. And then after the decisions were made on legal topics, the working group went through the table of composite score for competencies. And these are the ones selected and considered to be relevant or important to be included in the bar exam. Although, as I mentioned earlier, how to implement this decision in relation to legal topics, it's somewhat different because this involves more the question of appropriate task format. Anyone has any concerns or issues about the decisions made on these legal topics? And I should note that the decision on legal competencies, different than legal topics, is largely driven by the results of the study. And I see hands raised, and let me go back. Let me switch back. Emily, Leah, and Greg, should we go in that order?
That was, mine's from before.
Okay. Leah?
I just wanted you to elaborate when you say largely driven by the data. Can you elaborate, like where was there a deviation?
If you look at the results for competencies, here it's sorted in that descending order by the composite score, from 19 the highest for drafting and writing, all the way down to 4 in the composite. The decisions we made looking at this result compared to the decisions we made on legal topics is very different in the sense that we didn't have as many relevant and important policy considerations when we discussed the legal topics. For example, the foundational core nature of some of the topics, or some other options for appropriately addressing some of the legal topics. Here, in that last meeting, as we went through it, I get the sense that everyone thought the ranking made sense, and the process of going through this list and coming up with the list to include in the bar exam, there weren't other factors that people raised that caused any deviation from the ranking of this composite. That's what I meant about the largely driven by this rank order of the competency ratings. And going to Greg, you raised your hand.
Yes, Ron, I just want to say I think you've accurately drafted the report, or the drafters have drafted the report consistently with our discussions and consensus reached. The big issue in my mind on these topics is the whole issue of test format and reliability of being able to test these. And that's based on my previous experience with performance testing and the like. But you know, this I think report reflects the data accurately and reflects the judgments made by the committee at the time.
Although in general, the competencies compared to legal topics takes a little more time to address the issue of test format. Not all of them are required the same kind of effort. For example, drafting, writing, research, investigation, probably we could agree the current performance exam address that kind of a skill set. For when we come to litigation or counsel and advise, that's also included in the recommendation. How to test those, maybe an entirely different issue.
Well, as I recall, litigation has a number of subtopics in it, for example, drafting interrogatories and that sort of thing. Am I incorrect on that?
That's correct.
Yeah, so
that's where we need to go into the more detailed task level.
Right. So those are the kinds of things that, I mean, you mentioned the performance test. You know, we've seen, at least I've seen performance test items that have things like drafting interrogatories. So, you know, I won't repeat myself. This is a good list.
So as we were talking about either legal topics or competencies as the major focus of this study, and the expected outcome of the study is to come out with an outline or blueprint for the bar exam. By definition, outline is some high-level recommendations about what needs to be tested. Does anyone have any concerns or objections about decisions made on the competency areas? I think we can confirm again the consensus, the decisions that were made. The next one on our list is to get your additional feedback. Anything else beyond these two major recommendations that you think we should include in the final report?
I do have something, but I don't know how to raise my hand now, and I'm sorry.
Okay, go ahead.
So sorry. I guess this is kind of to Jackie's point about, well, 2 points that she's made. One being that if this is a starting point for other things to come, standard setting and other things, and also if we are suggesting that these are the topics and competencies regardless of format, that one of our recommendations be that our construct is adopted for future use, at least during this session of standard setting, if that's needed. But I felt like we had a really rich discussion about it, and I think it's indicated in the report, but it's not necessarily a recommendation that we're saying we think that the Committee of Bar Examiners should use or adopt this construct when thinking about minimum competency going forward. And then the second thing is to maybe a recommendation that if the format of the exam is, changed, that we are actually asking or making the recommendation that, that the group consider, whatever group is next, consider that these are the topics and these are the competencies, but that if the format, it's difficult to test something like that, that we understand that, so that we make room in the recommendations that these are our recommendations based on our knowledge now, certainly not thinking of a specific exam, but that future decisions on how to test these topics be based on what we are saying are the topics and competencies, making room for the fact that we understand that might be difficult. So I don't know if either of those two need to be actual recommendations, but specifically with the construct and how we have sort of defined minimum competency, I would suggest that be at least another recommendation.
I see that as an important point. We added a section in the working group report talking about the construct being the basis for our discussion. You all recall, we spent almost an hour or two trying to refine the construct statement as the basis for making decisions in the subsequent part of the process. So I agree that's an important part of the study and should be included as the recommendation, using that as the foundation for future definition effort to refine the minimum competence. As far as format and outline decision is concerned, logically, it almost follows the sequence of establishing the outline first, and then the next step is to determine what's the best test format. I'm not sure that needs to be called out as a recommendation.
That's a good point. I think you're right.
This is Greg. I think Emily's point is right on. I think some language in the report that recognize the limitations in terms of recommendations. These were the recommendations on the topic areas, but that's without consideration of whether current technology or technology available in reasonable future is sufficient given the resources to develop a reliable exam on those competencies. I think that's a huge question, and I don't want the record to not include my deep concerns about whether they can be tested reliably.
That's an important nuanced element to be added to recommendation. That brings, I think, us to the next item we're trying to finish, is to have 2 to 3 volunteers to work with us so that we can have all of these inputs incorporated into our final version. I'm not sure the best way of making that decision about is that. Yeah, only 2.
Yeah, and did we also want to just make sure both Emily and I think Greg had raised the possibility that there wasn't 100% consensus, perhaps, and that's something that we needed to mention in the report. I'm not sure we have enough on that to add. I mean, Greg, you raised like a minority report.
Oh, well, I'm not sure I raised a minority report today. I certainly agree that the draft report now reflects accurately discussions and the general consensus we reached at the meetings. People were not objecting strongly to the topics. I mean, I had my view that maybe there's some merit to going to UBE, which would, at least currently, doesn't have the administrative law. But you know, this is a California project, and the data shows what it shows, and I think the discussions were fulsome and good faith. So I'm not inclined to try to do a minority report on some things. I've expressed my concerns on the areas where I have some concern. Chiefly is the point I just made. So I'm not thinking about a minority report, if that's what your question is.
No.
I think for me, I wasn't doing necessarily a minority report, but I do think that within the working group report, there are ways to say the committee discussed heavily and saw points of view on both sides whether or not to include X, and listing some of the reasons that we discussed but ultimately decided not to go with, so that they, you know, the state bar, the committee of state bar examiners may also have those thoughts and wonder, well, I wonder if they thought of this, right? So that was why I thought that would be good to sort of put in.
Yeah, professional responsibility is a classic area, right? I mean, the executive summary says, well, leave it to a CLE later. But I recall discussion about, hey, you know, it's being handled by the multi-state professional responsibility exam, which is given more at different times, you know, by another, and that's sufficient. But there's nothing in the report about how that factored in our considerations.
And this is just on that point, and I don't know how to handle this in the report. We talk about the committee, but there are several people who didn't participate, yet their names are going to be listed, and they're going to be deemed to be part of the working group, even though they didn't fully participate. So I don't know whether it's fair to say participants rather than the committee.
Yeah, there are 2 people we haven't seen much of since the beginning.
Leah, just further to answer your question, from my perspective as the chair, I agree with both Greg and Emily that while there was a lot of discussion about certain issues and there was some difference of opinion, I think at the end of the day, we all came down to a consensus opinion that was agreed to in terms of being a consensus as opposed to a sharply divided opinion or report that would need a minority viewpoint expressed. So I think that the way that we've discussed just now handling the discussions is appropriate.
Great. For volunteers.
Volunteers.
Alan, I think you stated it. I think you stated it perfectly, and I would agree with that because I think it really has been a consensus process. I just want to make one point about back to the discussion on competency. I don't know if others have had the same experience I've had over the last few weeks. We've been inundated with offers about new examination technology. Okay, things are developing out there in really an incredible way. We're seeing that on the law side. I'm also seeing it with a son who's a senior in college in terms of how people are going through a process of interview in terms of competency and things like this, these interactive tests. I mean, the power of examination technology and the changes in examination technology are really exciting, and they've been accelerated by the whole experience we're going through now. So as we think about how to test these competencies and other things, I think we've done our groundwork, but I'm very optimistic, okay, that with the developments in technology, that we're going to find creative new ways to test these things if we give it a chance and if we're open to those ideas. So, I think a bar exam, as Ron says, this with this blueprint, there might be very, very different ways of constructing how we build it over the next few years that are really, truly exciting and that get us some of the things that we've all been talking about would be so useful to our profession here in California. So, who knows, right? But I'm pretty optimistic. This lays the groundwork for some good things with the technology that's coming along.
Yeah, I've stated my reservations about it. That's in light of current technology, if artificial intelligence and other things can do far more for us in terms of reviewing exams, grading exams, all that, that's great. I mean, I'm certainly open to the future too, Stephen. I think that we just want to be stuck in the past. So that's certain. But we have to be mindful of current resources and technology.
Yeah, I recognize that, Greg, with you. Yeah.
Okay.
So to get volunteers to work on additional revision of the report, do I have Dean Farola that you volunteered?
I'm happy to as well.
Okay, 2 volunteers. I think we can only take 2, right? Is that by rule or yeah?
Oh, well then, if somebody else wants to or whatever, I'm.
As long as it's volunteers, they're assisting staff, you can take a 3rd person. That's fine.
This is Sinead. Is this for the recommendation part or what? Because I know I said I would help with the administrative law and procedure recommendation. So is this the same thing or?
No, it's not limited to any specific. We're asking for volunteers to work on finishing up the final report and any questions raised, concerns, feedback that we want to make sure are incorporated into the final version. That's what the volunteer that we're hoping to work with the next week or so, trying to putting a finish.
Am I correct, as I've just volunteered myself, that I can also go to the committee members and get information? Like I can obviously talk with Shanae or talk with whomever if we need to do that, right?
I believe so.
Okay. Yeah, I'm not so sure about that.
I've hesitated to volunteer because I think it's the California project, and I'm not a Californian. But if you don't have a 3rd, I'd certainly be willing to do it. But I leave that up to you, Alan. I mean, what do you ever think is most appropriate?
I think so far we have Dean Farola, Emily, and Shanae. 3.
Oh, okay.
Well, you know, as the chair, I will, of course, volunteer as well. You don't have to pick me.
So I'll reach out to you to coordinate, hopefully, a speedy process of finalizing the report. And after finalizing the report, as I mentioned, the last question is, does the group still want to reconvene to review it, or leave it to the volunteer and have a chance to look at it again before we just say that's the final version of the report?
Ron, if I could just say, make sure that your number of volunteers does not equal or exceed a quorum of the committee, because that kind of sort of work offline would be inappropriate. That would need to be something that would have to be done in person.
Well, I think we ought to probably schedule a meeting, at least as a placeholder. I think once the rewrite is done, it would be appropriate to, of course, send out a smooth and red line version of the existing report so that we could all see what changes have been made. And then I think having at least a meeting scheduled so that we can ensure that everybody is essentially on board in a consensus position is the right thing to do. People can attend or not, but
okay,
at least it gives the opportunity for a discussion if we need it.
And what the sole purpose of that final meeting is to review the report, I think probably it'd be easier to schedule that for an hour or two rather than almost a full day. So I'll do that and find a time, and I'll follow up soon after we have some idea about the timeline.
So if I may ask, Ron, since you just said as soon as you have some idea about the timeline, I'm now going to ask you what you think the timeline is. And I only ask because the thinking had been that we'd be doing a presentation of the CAPA report, as well as the several other bar exam related reports that we referenced earlier in this meeting, doing that presentation to the Committee of Bar Examiners at their April meeting. And as we are sort of finalizing this CAPA report, I'm trying to get a sense of if that, if we'll still be able to present those reports at the Committee of Bar Examiners meeting.
What is the date of that meeting, Donna?
24th?
24th.
Next, so we have 10 days.
And this is Robbie. I'm glad you brought that up, Donna, but you know, I don't think we need to make an artificial deadline for that subcommittee. I'm happy to present these reports in their work in progress state to the CBE as they are, get the feedback that we might get, and then, you know, maybe share that with Ron and the other members that are firming it up. But we do have our meeting coming up on the 24th. I'll be happy to share with the members, you know, that there's still some fine tuning going on, but don't let our meeting date be your deadline date. You know, there's so much going on with the status of the baby bar and the July bar exam. I don't want to put any pressure on this committee to finish up the work that we've kind of picked up today. But if Donna, if that's okay with you.
Sorry, I was muted. Yes, certainly I'm supportive of that idea, Robbie, of presenting the sort of the near final draft to the Committee of Bar Examiners. I agree. We want to. The goal is to always get it right and not do it quickly, right? So, so we want to make sure that we've got the time to flesh out those areas that this working group felt like needed a little bit more meat on the bones in order to explain the rationale of the group.
And to make sure to present a near final report to the community bar examiner, it doesn't prevent us from bringing up the additional bar exam studies as a package. That was the goal, to present to the bar CBE the
Agreed.
April meeting, right?
Agreed.
Agreed. Yeah, that's true. Thank you, Ron. Okay, well, Alan, the meeting's ready to conclude.
I guess so. Anybody else have anything? Ron or Dag or Donna or Leah to begin with?
Alan, only something for you related to a 2 o'clock test run of our technology for tomorrow's meeting. You should see an email that related to that. And if you're free, I'd love to get you on another Zoom call.
Sure. Sure. We can do that.
Right. Thanks so much.
Okay. Well, then if no one has anything else, we will adjourn temporarily and reconvene as necessary, whenever.
Thank you.
Thank you
All
all.
right, thank you.
Thank you all.
Thanks,
Thanks
everybody.
very
Thank you
much.
much.
Thank you.
Bye.
Thanks, Ron.
Bye-bye.
Thanks, everybody.
Thank you.